the H-1B lottery electronic registration that starts on March 9th, ends on March 25th, how to navigate through the lottery process in the electronic system that we have. We're also going to discuss, once you file the adjustment of status, what are the next steps that are involved in it? As we know that a lot of people have filed adjustment of status in October of 2020 that are pending, and we're going to walk through the steps that are involved in it. Also, day one CPTs. I mean, it is becoming very popular nowadays that people who are not getting into the lotteries, they're joining the universities that give admission on the first day and give a work permit on that day. We're going to discuss what are the pitfalls in there, what are the problems people face if you join those kind of universities. Last but not the least, by the immigration bill, what are the prospects and what are the things that are expected, how long it will take. We will discuss more about the process involved. We already discussed many times before what is this immigration bill, but we're going to discuss about how the process is. Emily, on the H-1B lottery though, before I go, I just want to introduce myself. My name is Rahul Reddy. I'm a partner at Reddy Newman PC. Along with me is my business partner, Emily Newman. Emily, on the H-1B lottery system, how is it different from last time? And if I am an employee, what should I do to get in there? And if I'm an employer, what are the steps that I need to do to get my employee in the lottery system?
Sure. The good news is that the lottery this year is exactly the same as it was last year. Not any changes at all with that. So if you're an employee and your employer is planning on sponsoring you in the lottery, now's the time that you should be gathering your documents. Now, no documents are actually submitted with the electronic registration process, but your employer or their attorney needs to have your documents so that they can make sure they're submitting your registration with your name exactly how it's spelled on your passport, date of birth matching your passport, passport number, and your country of birth or country of citizenship. And then they also need to have your education documents so they can verify whether you can be submitted under the master's cap or not. And then it's helpful for them to also at least have your OPT card so that they can see whether that card expires before June 30th, because if it does and you're selected, they're going to have to file your H-1B petition earlier than normal to make sure that you qualify for the cap gap. So that's what the employee should be doing at this point. Employers, if you've not gone through the system last year, you need to be creating your My USCIS account. Once that account is created, your attorney will go into their account and start entering all of the information about the company as well as the employees that you're planning to register. So as of today, employers can create their My USCIS account, but the actual registrations cannot be started until next week, March 9th. So we have March 9th through the 25th to enter all of those in. Once the attorney enters the information in, we have to send a code to the employer. The employer logs into their account, enters that code, and then they will have the opportunity to accept the attorney's G28 as well as accept the actual registration. Then it goes back to the attorney to pay the registration fee of $10 per person, and then the process is finished until we find out who was selected around March 31st. The biggest pitfalls during this stage are making sure that you are submitted under the proper cap, whether you qualify for the master's cap or the bachelor's cap. Making sure all of your information that is submitted is accurate compared to your passport. And then making sure everything goes correctly with the actual electronic registration process and that it's not a duplicate registration. There were a number of people last year that had some issues with the registration being submitted twice due to operator error. So it's very important to make sure that it's only submitted once. If anything has to be withdrawn and submitted again, make sure the withdrawal goes through properly from both the employer and the attorney's side.
With regards to the adjustment of status, those people who filed in October, November, a lot of people are asking questions. What are the steps involved? If you have not already filed the EAD and advance parole, of course you can still file the advance parole and EAD even though the priority date is backlogged. We're noticing that the EAD and advance parole are getting approved somewhere in between 2 months to 6 months period. This is the time period that we're expecting. Though we stated previously about 8 months, but I'm noticing more approvals right now coming very fast on EAD and advanced parole. A lot of people are paranoid about the biometrics though. Biometrics is not needed to approve the EAD and advanced parole. Those are two independent things. EAD and advanced parole can be approved without biometrics. Some people get confused with regards to the H-4 EAD biometrics. There, when you file H-4 plus EAD, you may need the biometrics to be approved, biometrics to be done before the EAD is approved. But in this case, you don't have to get the biometrics approved. There are a lot of cases that EADs and advanced paroles are getting approved without biometrics. With the I-140, let's say you have filed an I-140 along with the adjustment of status. You can upgrade to premium processing. We are noticing some rejection of the premium processing. It's just the premium processing rejection, guys. Not your I-140, not your adjustment of status. And when they reject the premium processing, though, you'll get your money back. What we normally do is that when we file, sometimes they reject it, sometimes they accept it. We send it out in the next FedEx. After a couple of times, they are accepting the premium processing. This is happening most of the time. Now, some of the I-140s that have been filed are already approved. There is some concept that people tell me that if you file a premium processing, you will get an RFE. That has no truth in it, none whatsoever at all. If you tend to get RFE, then you will get it faster. That happens. But just because you file the premium processing, you're not getting the RFE. We strongly recommend all the people, unless you have any children who are teenagers born outside this country, to file premium processing, to convert your application to premium processing of the I-140. Now, so I covered the biometrics, the EAD advanced parole, the I-140. Now, couple of people are interested in, can I change the job right now while I'm in adjustment of status? To change the job, you require two things, which are must. The I-140 must be approved. The second one is that the adjustment of status must have been pending for more than 180 days. If you meet both the conditions, though, if you want to switch the job, the new company has to file something called 485J supplement. It's not as complex as 485. It is not as complex as the H-1B. It is not as complex as the POM application. It is not as complex as the I-140. It's more simpler than any of the forms that I ever know about. Now, the new company need to take the responsibility that they do have a permanent job offer with that company, and they need to sign the 485J supplement. If they don't submit the 485J supplement, if by any chance your previous company withdraws the I-140, the entire 485 might be denied. It will create a lot of problems. So if you're planning to move to a different company, make sure that the new company files the 485. Is it absolutely essential that the 485J supplement has to be filed before you join the job? No, it's not necessary, but it's strongly recommended that the new company needs to file a 485J supplement before you join. But it is not illegal if you file after a week after you join. That's perfectly okay to do that thing. Now, a lot of people say, when is my green card is going to be approved? Well, it's not going to happen, at least in the near future. The main reason is that for the 485 or adjustment of status to be approved, your priority date has to be current in the final action date. Now, when we file your application in October and November of 2020, though, the final action dates for most of the people were not current. It was only the filing dates that were current. So for your green card to be approved, your final action date has to be current. According to some estimates, approximately 400 to 500,000 applications were being received. We don't have an official count. This is just an estimate that we're having in the month of October and November. So there is a chance that there may be a significant backlog. So unless the final action date is current, you will not get the green card. The USCIS does not have any authority whatsoever at all to issue the green card. So you will have to wait for the final action date to be current. Anything else I missed out?
What about the people that didn't submit their medical exams? When should they worry about
Well,
that?
they don't have to submit right now, although I'm noticing that sometimes the USCIS is issuing the RFE. They can submit once the RFE comes in. You don't necessarily have to submit right now, but if the RFE comes in, you submit it. Otherwise, I strongly recommend do not, because if the final action date takes long time for them to become current, Emily, these medicals are going to expire. Medical expires every 2 years. If you file, you don't get the green card in 2 years, guess what? Your medical expires, you have to file again. We don't recommend unless they issue an RFE.
And how about the interview process? Is that still going on? Have they waived that?
The interview process is there since March of 2017. The Trump administration instituted the interview process, though. Because of the COVID, I see that they have waived the interview process for some people. It's up to the discretion of the officers that the interview process could be waived. Recently, though, I've noticed that a lot of people, especially the EB-1C green card applications, that the priority date, final action dates were been current, Emily, they have got through without interview for the employment based. We have to see as the things go on whether the Biden administration is going to completely take the interview process as it was before March of 2017. It could happen. Otherwise, I'm still assuming that they're going to waive for a lot of people the interview process.
All right.
Emily, on the day one CPT universities, and these are the universities, Emily, you can apply online. Of course, all the universities you apply online, and back in olden days it was different, but they will give you admission in 1 or 2 days. They don't have any qualification requirements. They don't require SAT, GRE, GMAT, ELS, nothing, and they give admission. And they give admission to doctorate, master, any program that you want. And the college starts whenever you want the college to start at. And you never have to go to college. Well, if the COVID did not exist, for example, these colleges only require 6 days of college in 1 year. You know, when I used to go to law school, I used to go to 6 days of college per week. These people are telling 6 days per year now, and they're issuing a work permit. What do you think about these universities? What is the legality of it? Why do we need H-1Bs? Why can't we send all the people to the day one CPT universities?
Right, yeah, you have to think about the concept of if it's too good to be true, it probably is. You know, and look at the universities that are providing this benefit compared to the typical universities that most people come to the U.S. to attend. The university that you probably graduated from does not provide the CPT. Why is that? You know, you've got to think kind of behind that. But the issue is, there are several issues. The first being, your purpose of that program of being an F1 student is to go to school. It's not to work. And when you're using these day one CPT programs and you're working 40 hours a week and going to school 3 days a semester, that sounds like your primary purpose is to work, not to study. So that it's completely opposite of what the purpose of an F1 visa is for. On top of that, the regulations say that if you're in a graduate program, you have to complete 2 semesters before you're eligible for CPT. These schools are giving it on the very first day before you've completed these 2 semesters, saying, well, it's required for our students to do this for their program of study. Look around, and you can't look around because you don't have classes to go to, but how many students attending these schools are not F1 international students?
Everybody is.
Everybody is. So of course the school can say, oh, everybody does this, but it's very questionable. They're just saying we require it without having any real explanation as to why it's mandatory for people to work during this program. It's not like medical school where you have to actually touch a patient, or
yeah.
nursing school or something like that, or a PhD program science where you're in the lab and have to actually do lab work to learn. This is not the same kind of program. The other issue, if you look at the schools that do authorize CPT, again, after they've completed 2 semesters, they tell you that if school's in session, you can only work 20 hours per week. Why is it these schools allow 40 hours a week when school is in session? On top of that, normal schools require that your employer be within a commuting distance of where the school is located. These schools have no such requirement. You can live and work across the country and somehow be maintaining F1 status. So all of these things tell me this is just way too good to be true. And you know, we've seen these schools for at least 3 years now, if not 4. We see people come to us only when they have problems, right? They're never going to come to us and say, everything's perfect with my immigration, I don't need you. They come to us when there's a problem. And many, many times people who are in these programs come to us with the problem. Can you give us kind of some examples of people who ran into problems after the CPT, like with their H-1B or their travel?
The change of status gets denied for these people because the USCIS does not consider them to be legitimate universities. We have had people who got deported when they were trying to travel from their home country into United States. We have issues with people who were traveling outside the country also where they were their visa was being cancelled. One time when the guy was coming in, he couldn't even name the city where his university was, so they deported that person. Routinely, we see change of status getting denied for these students. People challenge us and they say, there are 100,000 people or so, or whatever, thousands of people who are going to these universities. Let me tell you one thing. There are about 9,000 educational institutions that are authorized to give F1 student visas. How many do you think so are giving day one CPTs? Only less than 10. So out of every 1,001, that should tell you that there is something wrong. And out of those 10 universities, 2 of those universities, the Silicon Valley University and Tri-Valley University both of them, the authorities are in jail right now because they did fraudulent activities. These are 2 universities. There are 2 other universities, Emily, where the immigration sting operation, they put a sting operation. One is University of Northern New Jersey, one is Farmington University. These are the 2 universities. There's a sting operation. Sting operation means it's like this. The police officer will come, pretends as if that he is, he's a drug dealer and he's selling the drugs. And then when you buy it, he catches you. That's how the sting operation is. So when the police officer is pretending to be this university, you need to understand that there is something seriousness about these universities. Why would police officer not come and sell a Coca-Cola or Pepsi? He won't sell those things. He won't offer you, can I sell you Pepsi for 50 cents? He will not detain you if you buy it. That's not going to happen. He most probably will come with a marijuana, cocaine, or something like that. So it's like that. When there is a sting operation, that's another indication. A lot of people, when we tell them these are illegal universities, it is legal because it says it's legal. The university says it's legal. Let me tell you one thing. Even the President of America says that it's legal. It doesn't become legal unless it's legal. It is upon you to judge whether or not it's legal. Even anybody says, even the President of this country tells you it's legal to do it, it is not legal. So you have to be aware of the law. Not knowing law is not an excuse. So when you go into this day one CPT universities, you will be risking yourself. Please be watchful. Emily, now we have discussed a lot about Biden's immigration bill. Obviously, everybody knows that this bill has a lot of good things. It doesn't count the family members, which is a very good, best thing. It is very good. Absolutely, we all love this bill. There are no minus points on it. Now the question is, why don't you explain to me how this process of the immigration bill is? Do we have the bill numbers right now, or what is going on it? And how is this process going to go on?
Yeah, so we do have bill numbers. So because there's a separate bill in the House and the Senate, they each have their own bill number. So in the House, the bill number is H.R. 1177, and in the Senate, it's Senate Bill S. 348. Now, both of the bills have officially been introduced, And the next step generally is for the bill to be referred to various committees that are involved with whatever the subject of the bill is. So as of this moment, the Senate bill has been referred to the Senate Judiciary Committee. In the House, that bill has actually been referred to, I think, 11 different committees for review. So that makes me, yes, that means they're moving forward. That is a good step. But that tells me that there's going to be a lot of people involved, and there may be a lot of amendments to this bill, a lot of debate about this bill. So it's before the House Judiciary, Ways and Means, Armed Services, Education and Labor, House Administration, House Financial Services, Natural Resources, not sure why, Oversight and Reform, Foreign Affairs, Homeland Security, House Intelligence, and Energy and Commerce. Now, the good thing is with both of these bills, they do have a lot of co-sponsors. So the House bill has 117 co-sponsors already, and the Senate bill currently has 26 co-sponsors. The downside, none of the co-sponsors on either side are Republican, so this is still not a bipartisan bill. So basically, after a bill is referred to that subcommittee, the subcommittee is going to have their own debates on it, decide whether they can move forward with it, and they have to pass it out of committee. So we have to get through all of these House committees before it can actually be brought up for the floor of the House or the floor of the Senate. So we may not see any action really happening in the near future on this, but hopefully, it is intended for parts of it to take effect this October, so hopefully they will move on it quickly. But it's definitely got a long way to go.
I want people to keep up hopes, though. In the previous bills, though, both the bills, they got a similar kind of bills, though. One in Obama period, one in Bush period, though. They in the Obama period, it passed in the Senate. It never passed in the House. So we have hope there right now, because if this passes in the Senate, we have good chance that this will pass to the House, because House majority right now is Democrats. In the Bush period, though, it got about, I think so, it didn't get the 60 votes required. I think so, it got about 56 votes required, but shot only by 4 votes. Had it had the 4 votes, we would have not had this difficulty at this point of time. Keep the hopes high. There is a chance that the Democrats may do away with the filibuster. That means that we only need 50 votes in the Senate, and they already have the majority in the House. Keep the hopes high. Also, there is a chance they may split this bill into multiple pieces. Some of the pieces, everybody seems to be accepting, at least the majority of them. For example, green cards for the DACA kids, the kids who came under 15 who are unlawfully present in this country. Seems that that's going to go through smoothly, though. When it comes to the 11 million undocumented people, I don't think so that has a good support in the Parliament at this point of time, or Congress we call it here. When it comes to the business immigration, though, now, it doesn't fall into the same thing as the DACA, neither it falls onto the unlawfully present people in this country, the 11 million unlawfully present in this country. So we fall somewhere in between. So we may have to, we definitely have an uphill battle if they split the bill, which there is a good chance. So be ready, and we will update you when the necessity comes. We will draft you the letters, we'll post it on our website, and we will give a link to at this bottom of it. This may not be the right time for you to contact the congressman. When it gets to a certain stage where we think so is the right time, we will inform you. Please come to our channel every week, and we'll update you about this.
Time for some questions. Let's see. Somashri from Facebook wants to know any improvement on the H-4 biometrics timeline. In general, no, we're not seeing that coming through any faster. There's still a very large backlog of 1 million biometrics appointments awaiting. They're not reusing biometrics as much as we would have hoped. So it's still a long time frame. I think before I came in for this, I was checking processing times at the Texas Service Center, and they're 9 to 11.5 months for the I-539 application. So not getting any better, unfortunately. I do want to mention that on my blog, immigrationgirl.com, I do have a template letter that you can use to draft an email to send to your representative, send to your senator, just to raise awareness of this issue and how it's impacting your life. And it's really unreasonable that these applications should take this long. So in order to get action from USCIS, sometimes we have to get action from Congress or from the Senate overseeing USCIS to tell them they've got to fix these problems. You've probably seen recently that USCIS came out with new flexibility for F1 students for their OPT applications because receipt notices are delayed and processing times are long. Why aren't they doing the same for H-4s? I think F1s have universities that are advocating on their behalf, whereas H-4 applicants don't really have that. So you kind of have to band together and work together to advocate for yourselves. And one way to do that is to submit a letter to your representative and senator letting them know that this is a problem and urging them to push USCIS to fix the problem.
Navneet from Facebook has this question: can a spouse on H-4 EAD do multiple jobs? Absolutely yes, they can do multiple jobs. Selva from Facebook has this dilemma that he has. His priority date under EB3 is current. He filed the adjustment of status. His priority date in the final action date is current under EB3. He has already filed the adjustment of status in EB2. What should I do? I've been waiting for the green card for 12 years. Selva, I don't have an answer to you, but I will tell you what I would do if I were you, because there are certain things, the judgment call goes wrong. Believe me, there are a lot of times it goes wrong, guys. That's the reason it's very hard for us to tell you what to do. I'm an immigrant. I came through the employment-based green card. I understand the pains that you go through. I can only tell you what I would do if I were you. I will not do anything, Selva. I'm going to remain as it is. I'm not going to, substitute file an I-140 downgrade right now. If I were you, I will not do that. I will just do nothing. I'll wait for the priority to become current under EB2. Now, since you already filed the adjustment of status, I'm telling this. If you didn't file, if you were not eligible, now you're eligible for filing an adjustment of status. Now, we told a different story for the people in October. At the time, told everybody to downgrade and file the adjustment of status. Prakash from Facebook has this question. If somebody has a DUI, what are the steps that need to be taken? What will be the problems they'll face in the immigration? I'm assuming that your friend might have already hired a criminal lawyer to deal with the DUI. We are going to only address about the issues of the immigration. First thing is that if you have a passport stamping that is valid, that means, let's say, for example, you are an F1 or H1, validity period is, let's say, 2022. It is no longer valid. Now, that doesn't mean that you're unlawfully present here, but if you are planning to travel outside the country, you need to get the stamping before you come back into this country. Even though you have a stamping, it is not valid. That's one thing that you need to be aware of. When you go for stamping, though, there is a medical examination that happens. So once you go for the interview, they will tell you to go to the doctors. Once you go to the doctor's office, there is an extra 3-week process or 2 to 3 weeks process for you to get the visa. Be prepared to stay for that long period of time. While you are in the United States, though, whenever you file the adjustment of status, you are supposed to mention the DUI information. Even if there is let's say, previous to March of 2017, there was an interview waiver, but that interview waiver is, you will be interviewed for adjustment of status. You will not be granted adjustment of status without getting interviewed. Have I seen any adjustment of status denied because of one single DUI? No, I have not seen any adjustment of status getting denied for DUI. You just have to mention the details and supply the information, but it won't cause any problem in getting the green card.
Robin from YouTube wants to know if we can provide some details on promotion while you're waiting for the green card. Say your title changes from a developer to an architect. How does that impact the green card? It all depends, it's case by case situation, but in general, USCIS does recognize the idea of your typical career progression. And so if you are following the normal career progression that's normal for your industry, they are aware of that, and it should not have a negative impact on the green card when you're staying with the same employer. Now, so that would be something probably like a developer to an architect. But if you're going from the developer to the CEO of the company, that's a pretty big change. That's not the normal career progression. That could impact the green card and actually require a new labor certification, new I-140, in order for you to receive the green card. So it all depends on whether it's normal career progression, and that's decided on a case-by-case basis.
Das from YouTube has this question. Applied GC for mom. I'm assuming that it's a family-based green card for, she must have been the US citizen. Pending for 6 months, do we need to file the I-94 extension? Does the, if the I-94 extension is granted, does the AOS get invalidated? No, you should not file the I-94 extension though. Once you file the adjustment of status, if the I-94 expires, your mom is in legal status. Assuming you filed all the application properly and the US has received and acknowledged it, you should not file an I-94 extension. You're not eligible because for I-94 extension, you have to say that your mom is going to only live temporarily for 6 more months. But you have another application that says that she wants to live here forever. So those two are contradicting. It's absolutely not necessary, not recommended, and probably illegal to file an I-94 extension.
Ryan from YouTube wants to know, if I use the EAD and don't have an H-1B anymore, is it easy for me to get my spouse into the country? Unfortunately, no. Let's assume that your spouse has been outside the country the entire time. Maybe you left and got married and you came back in H-1B status and filed your adjustment of status, and now you have the EAD. If you let your H-1B go, your spouse is not eligible for the H-4. And if they've not filed the 485 because they're outside the country, they really don't have a way to get into the country. They have to go through what we call the follow to join process, meaning once you get your green card, they can follow to join you. That process adds an extra probably year to the whole process of her getting her green card to come into the US. So it'd be much better for her to come in on H-4 while you're still in H-1B status, and then have her file her own adjustment, assuming the priority date is current.
Augustine has this question. Filed the 485 application on October 7th and did not get the EAD approval yet. Should he contact the USCIS? Not yet. They're taking up to 8 months now, so you don't have to now contact the USCIS. As long as you have the receipt notice of the EAD, you are fine. Don't contact the USCIS yet. Emily, what about the premium processing in the H-1B quota? Will it be there this year, or will they suspend it for a period of time?
We have not seen any confirmation one way or another, so I think we'll have to wait and see on that still. Sohrab from YouTube says, why is specialty occupation definition so complicated? Do words like typical, mostly, or maybe, can they go against an H-1B application? Yes, they can. I would say it's slightly less of an issue now compared to what it was during kind of the heyday of the Trump administration. A lot of employers, or some employers who face denials because of that type of language, were able to successfully get the cases reopened by going to federal court and litigating those denials. And that created some helpful case law for us that we can rely on in the future to basically say that USCIS can't deny simply because it says those words, because the idea of specialty occupation is that it normally requires a bachelor's degree in a specific field. Well, normally and typically and mostly, most courts say those are all synonyms of each other and mean the same thing. And so we aren't having as much issues with specialty occupation compared to maybe a year or two ago, which is a good thing.
Sagar has this question. He filed the 485 application and there is an error in the last name. will that cause any problem though? Normally, it can be corrected by doing an interfiling. And even if when your wife goes for the biometric, you can mention it to them. We haven't seen people giving trouble in the biometrics. We haven't seen them getting stopped there. So their biometrics have been given. It can be corrected by interfiling, not a big deal. The only thing is that once you get a receipt notice, I mean, you pretty much are safe. If there is anything, there is a problem, they will issue an RFE, which is fine, you can answer it. Or most probably you can do an interfiling and request the USCIS to correct it. You can even do that clerical correction online right now with the USCIS, raising a service request about the last name, and they would be able to take care of it.
Rupika from YouTube got a change of status from F1 to H1 approved last year and wants to know if now's a good time to go for H-1B visa stamping and how long I can stay there. You know, the issue with stamping right now is mostly that the consulates are not operating 100%. So it's very difficult to get an interview appointment. And even if you do, people are facing cancellation. Some people have gotten canceled and rescheduled 4 or 5 times, and then they're stuck outside the U.S. the entire time. So I don't think it's a great time to travel right now if you need that visa stamp, because the consular operations are so unpredictable. There's no telling when you'll actually be able to come back. Obviously, people last year who left, you know, around this time thinking it was just going to be a 2-week vacation, a lot of people are still stuck in their home countries and haven't been able to get the visa still.
Sadhana has this question. My daughter and my H4 are still pending. My husband's H-1B has been approved. It's been more than 8 months now. Do we have to leave the country because it's more than 8 months, 240 days, I guess. That's the rule she is speaking about. Sadhana, that 240-day or 8-month rule is not applicable to you. Since your H4 is still pending and your daughter's H4 is still pending, you can stay legally in United States, no problem whatsoever at all.
Vishnu from YouTube already filed the 485 with a previous employer with the EB2 to EB3 downgrade. Now his current employer recently filed a perm application that got approved, and he wants to know, is it okay to file another I-140 while one is still pending? Yes, no issues with that at all. You can have more than one I-140 sponsored on your behalf, and they can be pending at the same time.
Rohini has this question. Can I apply for H4 plus an EAD while my husband's H-1B transfer and extension has been approved until 2024, but her H4 and EAD is expiring in 2022? I strongly recommend that you apply. There is a provision that says that you cannot apply for EAD extension if it's more than 6 months it's expiring. But we have not seen any problem whatsoever at all. When you file H4 plus EAD together at the same time, we have never seen them implementing that particular 180-day rule. In cases where people have got their H4 also approved, in cases where their EAD is valid for more than 6 months, when people have filed EAD extensions more than 6 months before, only one time that I have seen where they have issued an RFE and then we guided them to respond to the RFE, and that EAD was approved too. So, and I mean, we not only practice immigration law, we have a YouTube, we have a daily conference call that you can always come and ask the question. These are the feedbacks we get, guys. If there is some denial or anything that comes in, you guys give us a feedback. You know, we're a complete lawyer because of you guys giving the feedback to us. Of course, we do our cases, we do make money at the same time, but the YouTube channel that we have, the conference calls, the blogs Emily have, we get the feedback from you. If there is any denial, you guys point out, hey, my EAD got denied because I filed more than 6 months before. So we get the feedback. So based on that feedback, we haven't seen any denial. So Rohini, if I were you, I would apply for the H4 plus EAD immediately, because it's taking a long time to get the EAD approval nowadays. So I would apply for a H4 and EAD immediately for you.
Fanny from YouTube sent the L2 extension I-539 application for his 3 dependents to the Phoenix lockbox back in January, and of course has not received any acknowledgement or receipt. Problem is, his dependents' I-94s are expiring in April, and he's worried, is it legal for them to stay beyond that date if we still don't have any acknowledgement? So yes, we are seeing this major problem with receipt notice delays, particularly at the lock boxes, all of it kind of stemming to COVID and this big October rush with the Dallas lockbox, but still seeing delays in Phoenix as well. Now, although you don't have the acknowledgement from USCIS, you do have proof that you filed the I-539 timely. So you have your I-539 form copy. Hopefully you kept a copy of that. You have the FedEx tracking confirmation showing it was properly filed, and you submitted a filing fee check. You know, would I tell, you know, if I were in your shoes, would I leave by April 17th if I hadn't received my receipt notice? I don't think I would, because we know that the application was filed on time. You just don't have the proof of it yet. And I think it's safe for someone to stay in that situation. Now, if it was filed incorrectly and you know it was incorrect and it's going to be rejected, that's a different story. But assuming it was properly filed, you'll get that receipt eventually, and it will be backdated to the date that it was actually received, not the date that they're sending the notice in the future.
Emily, I want some discussion about getting married to the adjustment of status. I know in the month of September, October, we have defined the word marriage. It seems that it has gone nationwide now what a marriage means. They got it very clearly what a marriage to the adjustment of status is there. But let's clarify Raj's question, and then we'll go forward and why people are paranoid about it. I'm on H4 currently. If I use the AOS EAD, will my spouse get married to the EB3 status? The answer is no, your spouse will not get married to the EB3. However, Raji, the problem is, would your spouse willing to get the green card by himself without you? Most probably not. So if he is not going to independently get a green card and leave you out, then practically both are married to this application, unless he lets you suffer and then he gets a green card under a different category. So even though legally he's not getting married, but practically speaking of, if one person uses, the entire family is getting married to the adjustment of status. I know we define marriage at that point of time to give an education though, but is marriage something illegal to the adjustment of status? Why are people not getting married? Emily?
Yeah, it's not illegal. I mean, in most situations, unless there's something unusual in your 485, some kind of risk factor where there's a potential for denial, maybe your I-140 is not yet approved. That might be a situation where you don't want to be married to it, or maybe you have
teenage kids.
Exactly, teenage kids who need to have the option of switching from H4 to F1. They don't have that option if you've gotten married to your adjustment of status. But for many people, you do have that option, and it is a relatively safe option. I think a lot of people are kind of always wanting to have a backup plan, which is a smart idea. And that is the reason to not get married to it, is because if the whole reason to not get married to it is if your 485 gets denied, you still have status and can remain in the U.S. until you figure out how to fix whatever went wrong with the 485. But I mean, how many 485s for employment-based ultimately get denied? It's very rare. If they do, probably the #1 reason is because the I-140 got denied. So it is relatively safe. Unless you fall into those categories where there's a risk factor, where you have a teenage kid who's at risk of aging out, something like that, or your I-140 is still pending. Otherwise, it's so much easier to just get the EAD renewed every year, every 2 years, not have to worry about LCA, H-1B. We've got new H-1B wages coming up, possibly July 1st with this new regulation that we don't know whether it's been delayed or not. The H-1B process is always stressful for people. You never know if you're going to get an approval or a denial, even though you may have gotten approved for the last 10 years. It's just overly stressful, and I think more than anything, it's just lawyers being, #1, overly conservative, too cautionary, telling them all the scary stories and things that can go wrong. And number two, they want to make money.
They want to make money. If you are going to maintain the adjustment of status and H-1Bs, H-4s, EADs, yes, that's a lot of money. And every time you go to the consulate, you get the stamping. Oh my goodness, that's a lot of money. Believe me, guys, I mean, as we explained the marriage before, I mean, it's the same thing. It's you and this girlfriend, which is the H-1B is a girlfriend, and adjustment of status is your spouse. It's like this, you know, having a girlfriend for a long period of time, dating, living in two different houses, is very costly. It may benefit a lot of people, but not you. And if you're, you know, if you're going to be dating for her for 10 years, I don't know, it may be taking 10 years. You might as well get married and then leave the H-1B. It will save a lot of money for you. So my suggestion, unless you have something problem, if I were you, I would get married to this adjustment of status. And switching from EB2 to EB3 to EB2 and EB2 to EB3, it's not that easy as people think. There's something called caboose. You go at the back of the line. So if I were, I'm going to just relax and, you know, get married to the EB3 and settle down, because it's easy to maintain the adjustment of status. Now, I may go wrong in my judgment call, but I'm just telling, if I were you, I would get married to the adjustment of status if my I-140 has been approved. One condition. The second thing is that if I don't have any teenage kids whom I have filed adjustment of status along with me, I'll get married, and I will get rid of immigration lawyers in my life as soon as possible. Because in the adjustment of status, you require an immigration lawyer, but to very minimal extent. It's only 485J and maybe EAD and advance parole. For all these things, what I said, adjustment of 485J supplement, EAD and advance parole, what is the filing fees? Zero, zip. And for H, if you don't want to get married, you have to maintain the H-1B, H-4, H-4 EAD, and then guess what? EAD, advance parole, and 485J supplement. All these 6 things you have to maintain. And filing fees for the H-1B is not cheap. H-4 is not cheap. Filing fees for the EAD for the H-4 is costly. For the adjustment of status, it's free. So there are a lot of benefits if you would consider to getting married to the adjustment of status. Now, if you have overly concerned that what is going to happen, sky may fall down, and then guess what, the sky will fall down, an earthquake will come at the same time, and it will drag my leg into it, then you may want to consult a lawyer to ease up your fear, and then decide what you want to do. If you want to continue with the EAD and H-1B. Personally, I'm going to get married to the adjustment of status.
H1 Bro from YouTube has worked for company A for 7 years, but that company closed down, and he doesn't have an experience letter from that company. Now his new company is planning to file PERM and I-140, and of course, you normally need experience letters when you file the I-140 in order to get that approved. What would we do in this situation? So I actually have a blog post on this at immigrationgirl.com. It's a relatively old one, but it's still 100% valid. It's something to the effect of filing the I-140 without experience letters or something like that. But if you do a search there, I'm sure you'll come up with it. You can use secondary evidence. So if you still have your offer letter from this company and you have any kind of letters along the way about promotions or job changes or anything related to your job, those letters are primary evidence because they came from that company. You have 7 years worth of W-2s as well, and all your pay stubs. Those are all primary evidence, and then you can use secondary evidence to support that. Number one, you can, if there's any kind of news article about the company closing, you can print that out and show that to the officer. You can get an affidavit from former coworkers that were with you at that time that can confirm what your job title was, what your job duties were, and what your dates of employment were. So you have the affidavit generally from 2 coworkers, and then you support that with the other evidence I mentioned, such as W-2s, any kind of letters you have, any proof that the company has shut down. USCIS does generally accept that.
Good questions are coming out. Shankar has this question from YouTube. do we have to expect the 485J supplement receipt notice for all the adjustment of status applications filed? No. Sometimes they're issuing the 485J supplement receipt notices, especially when you file along with a 485 application. Sometimes they are not issuing the 485J supplement receipt notices. You don't have to be fearful at all if you didn't receive the 485J supplement receipt notice. Sushil from Facebook has this question. My wife's 485 was filed along with me. Her I-94 is expiring in June 2021 because of the passport expiry. What is the best way to extend I-94 without impacting her I-131? Good question. Normally, I would have said, hey, go to Mexico because our passport stamping is still valid and come back and extend the I-94. That's what I would have said. But since you do not want any impact on the I-131 though, I would not suggest that. If you don't want any impact, file a normal normal extension. Whether she's an H-1B or H-4, file a normal extension. In that way, you will not be impacting the I-131. Good, Sushil, that you've been watchful about this I-131. Good that you're knowledgeable that you know that if you leave the country, that the I-131 will be denied or it's not valid. That's good. You've been well educated and good, smart decision. Now, this question is a little bit more complex, Emily, then I will explain it and I want you to correct me though. Alaila Thirureddy from YouTube has this question. Will you please explain or guess how many employment-based green cards will be given to Indian nationals out of the approximately 250,000 green cards there? 7% is for sure Indians out of the 250,000. So approximately 250,000. So 7% will come to 14, maybe somewhere around 17,500 applicants. 17,500 are definitely guaranteed for Indian nationals. Now, the rest of the 250,000 green cards will be given to all other nationals. And if there is any nation that is filling more than 7%, they'll cut the nation out. The leftovers that are not taken by anybody else will be given to Indian nationals. And it's very hard to estimate how many will those leftovers will be. So 17,500 is guaranteed. The rest will depend on the rest of the world, how much they use, what are the leftovers of them. Those leftovers will only come to Indian nationals. Mostly Indian nationals. I'll be very surprised if there are any other nationals that will be in there. Mostly Indian national will get it. Emily, correct me on that thing?
Yeah, that's exactly right.
Now, can you estimate how much that wastage will be?
How much the wastage will be?
Yeah, wastage, because
gosh.
the wastage will be the ones which will be given. Based on my estimate, I'm expecting that the wastage should be around 100,000, Emily, because everything is current right now. EB2, EB3, EB1, everything is current for other nationals. Mm-hmm. So, and last year also it was pretty, on the same range. So I'm expecting 100,000. So this definitely is a big boon for Indians. This is just a guess because you told us to guess it. This is just a estimate. I may be wrong in it. Emily, any corrections on that?
No. Yeah.
Okay.
Chaitanya from Facebook wanted to know if we have any luck with Schedule A downgrades. So this is the situation. Schedule A gets to skip the labor certification and file the I-140 directly if they have a valid prevailing wage. And the question was, can you downgrade that without getting a new prevailing wage and basically filing it as a new petition? What I can tell you so far is that we have not received rejections. We actually did get receipt notices that they did accept the downgrade filing for Schedule A cases. We were kind of concerned that they would not even accept it because we're submitting it with a labor certification that's from years ago and is technically not certified. So we made some arguments on that and got it accepted. Don't know if it's going to be approved. I don't have any results yet on any of my Schedule A cases filed in October. Definitely, I will update you as soon as I get some news on that.
Rajeshwari from YouTube has this question. What are the comprehensive immigration bill, does it have any employment-based categories for the US degrees? Now, in this though, they only have special categories for the doctorate degrees, especially for the STEM extension, STEM doctorate degrees. As such, other than the doctorate degrees, there is no special provision for the people who have US degrees. But you don't have to worry about it if this bill goes through. I am expecting the priority date to be current in October of 2021. Why do I say that? The employment-based immigration is going up from 140,000 to 170,000. Well, that's not good enough to get everybody's priority date to be current. Yes, but they are not going to count the family members if the bill goes through as it is. So that goes from 170,000 to approximately between 340,000 to 400,000. That's a lot of numbers. Plus, there are unused green cards from 1992 to 2001 that are going to fall into this one. They are approximately anywhere between 160 to 250,000 green cards are going to come, plus the family members there. So you're expecting maybe around 600 plus thousand green cards to be available in October 1st of 2021 if this bill goes through. Not to mention that the family members counting is also taken off within 60 days from the bill is passed. If the bill is passed in this year, that is before, let's say in June or July, that means that the 250,000 green cards that we are mentioning right now and the family members will not be counted. So that's approximately 500 to 600,000 this year, plus 600,000 plus next year. Most probably everybody's date will be current, so you don't have to worry about flashing out your US degree. It doesn't matter. Everybody whose I-1 is approved will be able to file the adjustment of status. That is my estimate.
Karthik from Facebook has a family member who unfortunately overstayed the B2 visa by about 10 days because of flight issues during the pandemic and wants to know, does that mean his B2 visa is canceled? Does he need to go for a new one? Yes, and we actually have an article on rnlawgroup.com pretty recently posted regarding this situation because we kept getting this question quite often. So unfortunately, any overstay, if you overstay your I-94 that you were given and you're in B2 status, that B2 visa that you have that might have been a 10-year visa is automatically canceled. It's automatically invalid. So when you leave and you want to come back, you do have to apply for a new B2 visa stamp before you can come back to the U.S.
Shivani has this question. Has your firm received any EB2 to EB3 downgrade premium processing approval after getting receipt notices? Yes, we have. Many, plenty. Not just our law firm. The other law offices also received. It's nothing special about our law firm in this. Most of the law firms who filed it got it. Absolutely no problem with it.
Let's see here. Due to the H-4 EAD processing, this is Jay from Facebook, with the H-4 EAD processing time being so long, does it make more sense to transfer back to H-1B? And how long could that take as a cap-exempt H-1B? So this can be a good option if you held H-1B status in the past, but you did not use up your 6 years, and then at some point you converted to H-4, and you've been using an H-4 EAD. Now, if you are currently maintaining H-4 status and you're trying to get the EAD and it's taking forever, you do have the option of filing a change of status from H-4 back to H-1B that's not subject to the cap because you were previously counted. You can't start working based on the filing of that application. You have to wait until it's approved if your EAD is not valid at that time. But you can file it in premium processing to get it approved in 15 days. So it's a relatively quick way to overcome the H-4 EAD delays, but your employer has to be willing to file that for you.
Question about 485J supplement. Can I move from it to a different location with the same company? This question is coming from Coco Mist. If it's after 6 months, there is no problem whatsoever at all. if you move from company A's one location to another location. There's no problem at all. I mean, if within 6 months though, it doesn't mean that it's a problem. We need to look into a lot of different dynamics though. But if it after 6 months, you're clear, I have no doubt you'll be fine. You'll be fine to move to a different location. Ravi has this question from Facebook, and this is a question common that comes out very frequently. My priority date on my 485 receipt notice is wrong. Well, it's wrong for almost 90% of the people, guys. Don't worry about it. Don't panic. It's not going to do anything. I would not even bother correcting it. But if you want to, you can send you can request a service request requesting them to correct it, which they are not going to do it. But that doesn't mean it's going to harm you though. If your priority date, which most probably they have issued it on the day in October of 2020, if the priority date is October 2020, your 485 application should have been rejected. But it's not rejected, remember. So not a problem. I would not bother correcting it at all.
All right, I think we're about out of time for today. Thank you so much for joining us. If we didn't get to your question, please remember you can join our daily conference call by going to rnlawgroup.com to get the dial-in information on that. And you can always subscribe to our newsletter there as well, or subscribe to immigrationgirl.com for the latest updates.
Thank you very much.